Welcome, ladies and gentlemen. I'm very glad today to have this 4IP webinar that is called The Future of the Movie Industry in the Wake of Generative AI. That's very timely. And before moving on, my name is Axel Frazzini. I'm the Managing Director of 4IP Council, and I will be your host today. So, as you may know, 4IP is a not-for-profit organization based in Brussels, and we focused on the link between IP and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, the most brilliant, as you can see today, experts, IP organizations, and other stakeholders. On our website, actually, you can find everything like free materials. We have studies, we have summaries of relevant papers, recordings of our webinars, such as today, podcast interviews with inventors, entrepreneurs, and IP disseminators. We also produce an easy to digest content such as the SMEs Corner, especially tailored for non-IP experts and SMEs and startup. We also have an area on our website that is called IoT and Cellular Standards Made Simple, where you can learn about the benefits of standardization and the Internet of Things across different sectors. Check it out, and if you have any feedback, please let us know. We have also recently launched a new area called AI and intellectual property rights with guides, videos, papers, and interviews. The goal is to help you to understand how AI is revolutionizing the way we live, work, and create, but also the pressing questions raising about intellectual property rights in today's world. But without further delay, it is really my pleasure to introduce our speaker, Professor Dr. Eleonora Rosati. Eleonora Rosati is a full professor of intellectual property law at Stockholm University and of counsel at Bird & Bird. She also holds visiting positions at institutions including the University of Cambridge and Queen Mary University of London. Editor of the Journal of Intellectual Property Law in Practice, long-standing contributor to the IP Cat, that I'm sure you all know, and the co-founder of Fashion Law London. Eleonora is the author of leading works on EU copyright law and frequently advises international and EU institutions on IP matters. A final remark. Please, if you have any questions during the presentation, use the Q&A tool that you can see at the bottom of your screen. Do not use the chat, that's not going to work. So the Q&A tool, please post your questions. Don't wait for the last minute. And we will address all your questions after the presentation. Eleonora, the floor is yours.
Thank you so much, Axel, and for IP Council for the invitation and the opportunity indeed to contribute to important debates around the role, impact, and also threats that artificial intelligence is posing to the creative industries, including the movie sector. So the idea is for me to summarize the main contents and findings of the paper that 4IP has commissioned for a few minutes, and then leave much of the remaining time to indeed a conversation with whoever would like indeed to jump in by raising questions, comments, and so on. So indeed, specifically this piece of research related to the impact that the rise of generative AI would have and will have on the movie sector. And as a cover of my slides, I'm sure that most of you who are interested in this area will recognize what has been presented as the first AI actor, Till Norwood, who has indeed been unveiled just a few days ago. So the question is whether the future of the movie industry is going to be one in which we don't even need human actors any longer, but it will be AI assets that take the scene. So this, as you may appreciate, is something that is considered as very threatening by also representatives of actors, trade unions, and so on. I would say that when we speak about AI in the movie sector, like any other creative sector, we have a coin with two faces. Let's start from the potentially, and I'm stressing potentially, positive one. That is the implementation of AI tools for content creation, content editing, and so on. The example is indeed on the right hand side of the slide. You see that AI has been used to make real actors look decades younger. This was the case of Tom Hanks and Robin Wright in Here. Also, another example is the use of AI to perfect the actors Hungarian in The Brutalist, which was the awardee of indeed Oscars at this 2025 edition. But indeed, the use of AI is growing and growing, also to do the job that in the past special effects would have done. So this is unavoidable, it is something that is being implemented across the board, but of course it has also a potentially negative side, that is the displacement of many of the existing workers, ranging from actors to those in technical roles and so on. Just yesterday, there was the conclusion of the WIPO's 12th conversation, specifically focused on synthetic media, and there were indeed the representatives of actors, SCAG, AFTRA, speaking and addressing specifically the rise of synthetic media, also reproducing actors' likeness, and stressing the need for consent on the side of actors and the opportunity for them to be able to negotiate the terms and conditions of the use of their persona, including likeness, voice, and other personal attributes. So that is something that is happening. There are also some voices speaking of AI as enhancing one's creative potential. There are companies that only implement AI tools. One of them is the Door Brothers, which have gone viral with a series of contents over the past few months and have spoken also in an article that was published not long ago on the New York Times as AI allowing purest forms of creativity and imagination. Then there is the other side, which I think is emerging quite strongly in the plethora of lawsuits that we are seeing being filed over the past few months. And it is related to the image that you see on the left hand side. This is taken from a complaint filed in California a few weeks ago, in which indeed many studios allege that Midjourney not only has been using their content for training purposes, but contains several instances of training data regurgitation. These that you see on the slide are outputs created using Midjourney. They are remarkably similar, if not identical, to famous content protected by copyright and other rights. So these lawsuits address the use and ingestion of protected content for training purpose and indeed the lack of any authorization on the right holder's side. So these elements are mapped a bit more in detail in the study and showcase how the movie sector is going through a phase of transformation similar to any other creative industry. So specifically what is addressed in the study and that I would like to briefly present is in essence the two main moments of input AI training and output generation. Insofar as the former is concerned, the biggest dilemma, if you wish to call it like that, is the interplay between control by means of licenses and the applicability of exceptions that would allow AI developers to use protected content without the need for authorization from relevant right holders. This, to be clear, is a debate of global relevance. There are some countries that over the past few years have introduced specific exceptions, not for AI training, but for TDM, which is not necessarily the same thing. The vast majority of countries which so far have not legislated, including the United States, where current court cases are testing and, if you wish, potentially also stretching the borders of the US fair use doctrine. And then there is a group of countries that are considering potential reforms. Just a few days ago, there was the announcement on the side of the Australian government that while Australia wishes to promote innovation in the country, there will be no introduction of a specific TDM exception in that country's copyright law. On the European continent, we can recall the debate currently ongoing in the United Kingdom. As you may know, the UK was the first EU member state at the time to introduce back in 2014 a text and data analysis exception. Since then, a lot has happened, including Brexit, and right now the UK is considering a potential reform of its copyright law, including by broadening the existing provision found in Section 29A of the CDPA. This debate is still in search of a resolution. The UK government ran a public consultation between the very end of 2024 and February 2025, but at the moment an official response on the side of the government is still pending. Consultation that, by the way, attracted a lot of interest, with reports speaking of over 11,000 responses submitted. So this debate, which can be summed up as licensing versus exceptions, is one that is unfolding around the globe. Then, coming to output generation, there is an area that has indeed been debated for a long time, that is the protectability of AI-generated, AI-assisted outputs. And what began as an academic debate is now indeed being populated with a number of decisions in various jurisdictions, ranging from the United States to China, a decision in the Czech Republic, etc. What seems to be the broader consensus? That to have copyright protection, a human author is needed. This is the broad consensus. There are some exception to this rule. For example, the UK rule contained in section 9.3 of the CDPA. So that the real question is not really whether AI can be an author, but rather to what extent AI can be used and one can still be regarded as the author of that output. This is a question that depends on the circumstances at hand, but I think is the only meaningful one to raise in this context. Last but not least, when it comes to output generation, the biggest issue right now on a practical level is probably the risk associated with the use of AI tools, especially those trained by third parties. What if you use someone's AI tools and the output happens to infringe someone's copyright? Who will be responsible for that? Is it you as the user of that tool? Is it the developer of such tool? If we look at most AI developers' terms of use, the response is that any liability is on the user. This is something that I guess will attract case law and indeed the contentious proceedings also on the side of consumer organizations to test the very validity and enforceability of these terms. But at the moment, a lot of the work is being done in this sector with indeed a basic fact that many of these situations are not subject to individual negotiations between AI developers and users, but rather the latter accepting the blanket terms imposed by AI developers. So, elaborating further on what I've illustrated, let's start with the input side. As I mentioned, it is important to note that the countries that have adopted the specific TDM exceptions have indeed done so. So these are exceptions for text and data mining. They are not exceptions for AI training. And so a lot of the discussion so far has been but when these exceptions were introduced, was AI even contemplated? My answer is yes. If we take the EU exceptions, back when they were adopted in 2019, it was clear that TDM could be relevant to AI development. And there are documents, including at the national level, for example, the report that Cédric Villani prepared at the request of the French government that specifically tie TDM to AI development. So I think that that is clear, and it is now even clearer following the adoption of the AI Act, which crystallizes the relevance of TDM exception in the context of AI training. But this, I think, yes, I've seen a lot of people feeling very passionate about this topic, debating passionately, but if I may, is a rather dry and useless discussion to have. The real point is the following, and on that I think we cannot really have doubts, that TDM is part of AI training, but is not everything that AI training does encompass. If we look indeed at the various provisions that have been adopted around the world, I'm crossing the US because, as I said, no legislative intervention has happened there. We see with the potential exclusion of Japan, which by the way has an exception that is formulated in very ambiguous terms and by the way remains unapplied today. We see both in Singapore, UK, and at the EU level that these exceptions for text and data mining, so purpose specific ones, cover specified restricted acts under copyright. So they cover extraction insofar as the sui generis database right is concerned and reproduction. But reproduction for TDM. The training of an AI model entails, amongst other, reproduction done at several different stages. And if we focus on output generation, the claim that this is a new reproduction is a fair one to make. And clearly, if the output reproduces the training data, by no means this will be covered by the TDM exception, because it will be a reproduction that happens beyond the purpose for which the exception is in place, that is text and data mining. And indeed, if we consider a potential case of AI model training, we see that there are several different rights that are engaged at different stages. What you see on the slide is indeed a factual background that I have borrowed from the German Lion case, with which many in the audience will be familiar because it has been one of the very first few TDM cases around Europe. So far we've had decisions on TDM in Germany, in Denmark most recently, and also in the Netherlands. Apparently there is also a decision in Hungary, but so far the picture is far from complete. In any case, what you see on the slide is what I've borrowed from the factual background to the Lion case. So we start with the scraping crawling of protected content on the internet. This entails engaging the sui generis database right. By the way, the CJU is adamant that the notion of database should be construed broadly, so pretty much anything is potentially a database, and an act of copying that has been undertaken. Then Lion created a data set which entails the making of another copy. This data set was published online for everyone to download and use, and this publication of the data set might engage once again another act of copying, as well as the right of communication making available to the public. If an AI developer downloads the dataset, the downloading entails a reproduction. The training can engage once again the sui generis database right, as well as the right to control the making of copies. And then the use of the resulting model can engage once again the right of reproduction, as it is the case here, the right of adaptation, communication making available to the public, distribution if these outputs are being sold, and so on. So, to my mind, the conclusion is that the TDM exceptions, no matter which ones you consider, do not cover the entirety of AI training. There is another consideration to make, that when we speak of exceptions, they are all framed within the requirements of the three-step test. Fair dealing insofar as the UK is concerned, but incidentally, the meaning of the fair dealing notion is the same as the three-step test, as recognized also in relevant UK case law. Then the Court of Justice also tells us that there is an additional requirement that applies across the board, irrespective of a specific mention, and it is the fact that for an exception to apply, the underlying work must have been accessed lawfully. Example, if you circumvent technological protection measures to watch a sports event without paying for the relevant subscription, and you indeed reproduce that sports event, that broadcast on your device, that act of reproduction is not covered by the temporary copies exception, because lawful access would have not been secured in the first place. Now, Article 5.1 of the InfoSoc Directive specifically refers to that, but the same is relevant under any other exception, including private copying and so on. So, contrary to what some commentators have submitted, is not that the three-step test, that exception only apply to certain special cases which do not conflict with the normal exploitation of a work and do not unreasonably prejudice the legitimate interest of the right holders, is an extra thing. Is how all exceptions must be construed, and this comes from international law. So I don't see how it is possible to contemplate a situation in which the TDM exceptions are construed so as to cover the entirety of AI training and even output generation. If nothing else, the three-step test would prevent that, including the normal exploitation requirement and the no unreasonable prejudice requirement. To conclude, what I've just said in relation to TDM applies to any other exceptions. Those, for example, who speak of AI models learning how to produce output, and so suggesting that education-specific exceptions might be relevant, again would be disappointed to hear that none of them covers the entirety of AI training. So that is the first group of conclusions. Coming to the second block of issues, the generation of output and the question of protectability thereof, here we've had indeed a number of case studies which have also mentioned the use of AI tools in content creation and production, but even the generation of what is presented as entirely AI generated. As I mentioned, the real question is not really whether AI can be an author. This is a question that might be fascinating to some, but in practice is of very limited, if any, relevance. The real issue is indeed whether one can use AI, to what extent, and still be regarded as the author of the resulting output. So, in essence, it is a question not really of human authorship, but human creativity and originality, because the author, even though there is no definition in international law, is the person who controls the creative process, and by control I mean who exercises the free and creative choices that are at the basis of the originality requirement and are needed for copyright to arise. So, in essence, AI must be serving human creativity for that output to be able to attract copyright protection. And this conclusion is in line with the few cases decided so far, including the decision at the level of a federal court regarding a recent entrance to paradise in the US, the registration of a single piece of American cheese by the US Copyright Office, and decisions like that of the Beijing Internet Court in Li and Liu. All these cases show that the claimants, or indeed applicants in the case of the US Copyright Office, were able to demonstrate how the creative process unfolded and what was AI and what was instead their creative control over indeed the production of a work. The same I expect to be applied in future cases, including those decided in other jurisdictions. Coming to the final topic, that is the liability for the use of AI tools, here we have a number of questions to address. The first one is whether doing something in the style of someone else is actionable or not. And here I refer to a case that has been discussed in every possible way, that is the deblification of OpenAI. There was indeed the release of a new version of a ChatGPT image generator that allows the creation of content in the style of Studio Ghibli creations. This is something that was unveiled a few months ago. Sam Altman also Ghiblified himself, and from a copyright standpoint raises the question to some extent whether styles are protectable. I will say that more correctly, here we're not speaking of simply styles, but rather reproduction of protected content. But let's assume that the starting point is correct. We are speaking about style imitation. The question is whether style is protectable. And here, if you open any copyright book, you will see also discussed very much in passing that styles are ideas, so they are on the idea side of the idea expression dichotomy, hence unprotectable. Now, I would like to point out something that I always tell students. That is that the phrase idea expression dichotomy is very misleading. Dichotomic means yes or no, black or white, square or circle, and I wish that things were that simple in reality, but unfortunately they are not. It is more correct to speak of an idea expression spectrum. There are things that for sure are on the expression side, things that for sure are on the idea side, but styles are somewhat in between, and I believe that a sufficiently detailed style can fall on the expression side of this spectrum and qualify as a work, as also interpreted in relevant case law. So if it is a work and it is sufficiently original, a style is protected by copyright. And when I have something like, for example, Emily in Paris, who is a character played by Lily Collins, and indeed has a specific appearance in terms of age, in terms of ethnicity, in terms of indeed hairstyle, makeup, and so on. And I see something like this, which I generated using an AI service. I think that it is quite close to the original Emily, not only because of the outfit, which I can see is different only in color, despite the fact that you only see the higher part, but you can see that this AI model knows that Emily is a young woman, she's white, brunette, has rather thick eyebrows, and a certain look and feel in her face, makeup, and expression. So, bottom line, when we speak about style imitation, we are speaking about something that is potentially protected, and it is therefore no surprise that many AI models refuse to execute a prompt that contains the instruction in the style of and the name of a work, the name of an author, and so on. So, coming towards a conclusion, also to leave space for the discussion, On the topic of liability, there is the question of who will need a license from relevant right holders. It is the user, the model developer, the model provider, which is not necessarily the developer. I think that potentially all of them would require a license, but in any case, it is important to note that many of the exceptions that are available under copyright will be covering users and not developers providers. Here, the case law that has developed around the platform liability can be of some assistance, and indeed, in Europe, it is important to remember that the case law and now the legislation has identified the possibility of direct liability of platform operators for user uploaded content. So if someone uses an AI model to generate an output that infringes, the liability may not necessarily vested only on the user, but can also extend to the provider of the platform that is used to generate content. So, coming to a conclusion and to sum up, clearly AI is presenting a number of opportunities, including creatively, but also threats and the potential of displacement of many creative workers who, by the way, have had not only their efforts but also creative outputs, performances, works, and so on, used to train these AI models. When it comes to training, the interplay between licensing and exceptions, I think weighs in favor of licensing. It is, to me, quite risky to train an AI model without any permission in place. And indeed, if we look also at the early case that is emerging, this might be the right thinking. And also seeing what kind of deals are present on the market, there are many leading AI developers that are deciding to proceed with a licensing approach rather than indeed rely on potential exceptions and fair use. Then, when it comes to output generation, AI can be used in different ways, but for that output to be protectable, AI needs to be an aid, a tool that serves human creativity and not vice versa. And finally, with regard to liability considerations, I reiterate what I've just illustrated and stress once more that it is a bit too superficial to dismiss the protectability of styles altogether. And here I conclude with a quote from a rather dated English judgment in which the then Mr. Justice Robin Jacob admitted that yes, the taking of an idea is not actionable, but the taking of a detailed idea might be. Behind that thinking, clearly there was the consideration that ideas transition into expressions and styles are indeed at that point of transition. So with that, I conclude my summary of the paper. If you want to read more, the paper is available on the 4IP website, as well as on Computer Security Law Review in open access format. Thanks again for having me, and I look forward to the discussion.
Thank you very much, Eleanor. It was very interesting. And we have received a lot of questions. So let me just start with the simple one. You spoke about licensing solutions, but are there any in place?
The answer is yes. Of course, many of the details are confidential and we don't know and don't have access to them. But seeing what has been reported by the general media, there are licensing solutions that are achieved successfully. That has been particularly the case, for example, of the press and music sector. Just yesterday, there was indeed the announcement of a partnership between Universal and Udio, and this adds to the growing list. So direct licensing, but also collective licenses. These are being developed by collective management organizations such as CCC in the US, CLA in the UK, and also Steam in the music sector announced that they will be proposing the first collective license for AI and music. So I would say that the market is responding, and this will likely be the case also of the movie sector. I don't see how it is contrary to right holders' interest having to ask for their permission, because I've also read that and I was a bit surprised to consider the need for permission as being detrimental to someone's own interest.
Yeah, indeed, that's very good. We received several comments. I suppose there might be students they are saying, but how are you keeping up with the load of rapid advancement in AI and
Mm.
copyright? Can you just recommend a few sources?
Sure, indeed, this is a great question because there is an influx of information and developments every day. I personally find LinkedIn a very helpful source. So there is a number of great accounts of people that share the latest developments. So I suggest, and this person can also contact me privately after the webinar to follow these accounts. And then, of course, there are blogs reporting on these developments, not to promote ourselves, but IPCAT is one of them. And then also the Clover Copyright blog. There are also some blogs in the US, mostly updating around new lawsuits that are being filed. And then a lot of the discussion also is taking place on general media because these have become matters of general interest and no longer of interest to legal specialists.
Very good. I can only recommend everybody to download your paper that is available on the link that you provided. And by the way, the slides will be made available tomorrow. So everybody will have access to the link provided, but on the 4IP website, you can already download the paper. So a lot has been said about potential forms of TDM exceptions. How likely are they to go through?
But in terms of their application, I think that we shall see what happens. Of course, many courts are faced with these questions for the first time. In many countries, there is no real precedent on TDM applications. So I think that the case law will mature as we go forward. In terms of new TDM exceptions, as I said in the opening, Australia said no just a few days ago. For the UK, we shall see what happens. But if the model that the UK is getting inspiration from is the EU one, in particular Article 4 and the reservation possibility, I think that they have an opportunity to do a better job than the EU legislator, for example, having regard to the rights reservation possibility. This is proving to be very contentious. If you look at what is available in European case law, it seems that every court has a different idea of what rights reservation should look like. So again, if the UK government thinks that the European Union Article 4 model is the right one, which I guess we can have a discussion on, they should indeed avoid the mistakes and ambiguities of what is contained in the DSM directive and many of the resulting national transpositions.
Okay. Very good. So you referred to the lawful access requirement and the three-step test.
Mm.
Can you just elaborate further on how they relate to existing exceptions?
Sure, this has been a vexed issue for a very long time, no? Let's take private copying, which I mentioned briefly. It is an exception that exists in most European countries' laws. One notable exception is the UK, where this exception was introduced in 2014 but quashed a year after. So, apart from that, private copying is the possibility to make copies of indeed copyright protected works. A vintage example might have been you buy a CD and you make a copy to keep it in the car, no? But of course, today private copying applies to different devices, who is responsible for payment of the compensation. There is a lot of litigation around it. When the Netherlands transposed this part of the InfoSoc directive, they didn't discriminate between lawful and unlawful sources of the content. And indeed, the idea of the Dutch private copying exception would be that also illegal downloads from the internet could be saved by the private copying exception. As early as 2014, the CJU said that is not the case. Lawful access is a requirement. So, when it comes to content used for training purposes, if the content resides on a website whose terms of service are clear, that you cannot use that content for any reason or even limited just to TDM AI training, I think that the source of that content is immediately poisoned and cannot be regarded as lawful. So I don't see how in a situation like this one could successfully claim the application of the TDM exception. And then coming to the three-step test, this is how all exceptions are construed. And the normal exploitation of a work, as understood also by the WTO, is through licenses. And it is not just existing licenses, but also potential ones that will be emerging. So an overbroad construction of the TDM exceptions has the potential to kill this emerging market for licenses. And I think that this shows how the three-step test would prevent such a construction of the resulting legal framework. So to conclude, lawful access and three-step test are inherent to all exceptions. They are not extra requirements. And if you take the example of the European Union, the fact that Article 7 of the DSM directive references the three-step test is not to add something that otherwise would have not been required. It's just a clarification of something that is the law, that the three-step test serves to construe all exceptions, including the TDM ones.
That's very good. A question that is really focused about the movie industry,
Mm.
which is, are you aware of a question before the movie studios, aside from the pushback from actors and writers, that using AI could actually lead to unprotected parts of their movies? Or
Mm.
the movies are too complex of works for this to be a concern?
But that is potentially an issue, but once again, the answer is what is being copied. I doubt that you would have at this stage, going forward, the answer might be different. A movie that is completely AI generated and there is no human input whatsoever. At the moment, AI is not capable of generating something without some form of human control. The catch for those indeed seeking to protect and enforce successfully rights in movies that have AI assisted generated parts is to carefully document the creative process. This is something that has always been important, despite what one might have been taught in light of the no formalities rule, etc., of the Berne Convention, but it's becoming more and more important going forward. So if we look at those who have successfully received protection for works generated with the aid of AI, they are all people who were able to provide a trail of evidence showing what they had done. So I think that going forward, this record keeping exercise might become more and more relevant. But again, it is not a new thing. It is something that AI has potentially made more acutely important.
Okay. And do you think that the EU AI Act um, will achieve its goal of what some have called extraterritorial application of EU law?
Mm. The right answer is always it depends. It depends on what relevant authorities will make. Here, the references to Article 53 of the AI Act, what will make of this provision. So, in essence, this part of the AI Act does provide that no matter where the training of an AI model takes place, compliance with EU law, including but not necessarily limited to the TDM exceptions, need to be secured. So some people have spoken of extraterritorial application of EU law. Personally, I'm not sure that this is a correct characterization. And I'm borrowing from the case law on internet-related activities that the Court of Justice has also come to address. So it is not here an extraterritorial application, it is a situation in which there is a clear connection with the European Union that is specifically the placing on the EU territory of an AI model, and therefore the application of the EU legal rules, including those for TDM. So that is how I will characterize it, but once again, we shall see once the AI Act gets enforced what relevant authorities will make of this provision and whether Article 53 has actually killed any possibility of deviating from the EU model, thus rendering the efforts of other legislatures to adopt a more relaxed approach vain unless one AI developer says I'm happy to opt out of the European Union, a market of 500 million people. Again, we shall see, but that is the ambition of the AI Act.
And you consider styles protectable, but is not it contrary to the idea or expression dichotomy?
As I said, I don't think that that is the case because indeed are sufficiently detailed and I would say also recognizable. Now, I guess some people will criticize me for using this expression, recognizable, but indeed a style can become a protected expression by means of indeed sufficient sophistication and indeed development. I see also that an attendee asked the question whether styles could be protected under the UK tort of passing off. Beh, the answer is yes, provided that the relevant requirements under the action are fulfilled, including that there is a goodwill to protect. So I'm sure that everyone believes that they have their own style, but under passing off there are some styles that are more deserving than others of protection. So clearly celebrities and other people who are in the business of licensing the use of their style will be also receiving protection under passing off. So it's not mutually exclusive, but can be cumulated. And from a European continental perspective, you can rely, for example, on unfair competition, which also is construed in some countries rather broadly.
Okay. And what do you think the CJEU will rule in Pelham 2 regarding the notion of pastiche?
Mm. So this is a case that has gone on in Germany for 2 decades. It saw a first installment before the CJU with the result that the case has returned to the Court of Justice. Why? Because Advocate General Spooner advised that perhaps that unauthorized sampling could be a case of pastiche, and I guess that that has been at the basis of the subsequent developments in the case and the new referral. So pastiche is an exception that so far no one has really paid attention to, also because in the past there has been the conflation by people like Advocate General Cruz Villalon, who was the AG in Decmin, with the concept of parody. But now it seems that it has acquired a life of its own, and pastiche is the imitation of one's own style for homage purposes. So there is not a humorous, funny element that characterizes parodies, but rather a dimension of homage. And to me, the very fact that pastiche does exist as an exception to copyright demonstrates that styles are protectable, because pastiche is about the imitation of the style of a work, and I believe that the fact there is a copyright exception suggests that a style is protectable. Those of you who have followed this case will be aware that Advocate General Emilio issued his opinion a few months ago, and in essence he advised the Court of Justice to provide a certain construction of pastiche. He also admitted that styles might be protectable, and I expect that perhaps not with the same level of detail and articulation of the Advocate General, the Court of Justice will follow his broader guidance.
Okay. So several questions are related to the same topic. So let me just reword it um, in a simpler manner. So how can users of AI tools can actually protect themselves?
The answer is it's unclear at the moment because what has really surprised me is that when we speak of users, we are not just speaking of individual ChatGPT subscribers, but rather big organizations and companies. And these so far have implemented AI tools in their business functions without even negotiating individual terms with these AI developers. So we are speaking not just of the individual person making this choice, but big organizations with indeed impressive turnovers and revenues. So if you can afford it, my advice would be do negotiate the terms of indeed the agreement with these AI developers and pay attention to what is written in relation to potential liability exposure. For the others, individual users who are not in a position to demand such an individual negotiation, my advice is to be mindful of the potential risk that one is exposing themselves to, which are real and might become painfully acute going forward. I'm not aware of anyone, individual user, being sued yet for using an AI tool. The lawsuits are against AI developers, but I guess that this will be the next installment in right holders enforcement efforts.
Okay. So I know that you don't have a crystal ball, okay, but several questions are related to what's your opinion and what about the future. Um, so how do you see the use of AI in the creative industries develop going forward?
But I think that from the point of view of training in the medium long term, I think we will have a licensing horizon. Also, these AI developers, right now there are several of them, but the market is bound to become more and more concentrated, and those who emerge are also those who are not getting sued, I think, and are required to pay very hefty damages. So I think that the future is one of licensing and indeed the collaboration between right holders and AI developers. This is a transition from a technological standpoint for which there is no way back. Clearly, AI is here to stay like the internet, and after this initial phase, like the internet, there will be a growing maturation of the market and probably indeed the emergence of a licensing approach. What I think is perhaps more uncertain is the future of many industry workers because when it comes to technical roles, the use of AI will be likely implemented by studios, and this would entail fewer technical indeed workers needed for productions. For actors, I think that the situation is different because, yes, there is a flooding of synthetic media on social media, etc. But the value of authenticity, the craft of an actor, and the emotions that an actor is able to generate in the viewer, those are uniquely human. And I don't see except perhaps for some genre like cartoons and so on, AI replacing actors. But nevertheless, it is important that those representing actors are being very careful on assisting their clients in their contract negotiations, and indeed trade unions have their voices heard, so that the industry does not create a existential threat to the very workers that it needs instead to protect.
Okay. And several questions are related to the heritage, not only in the EU, but maybe in Japan. We have seen that uh, strongly, um, deeply actually understood uh, in the culture elements. Let's try to frame it that way. But how do you see the use of AI in the creative industries develop? No, we have seen this view, but how can you really protect the creators?
Mm.
So we can see that there is people worrying about this.
For sure. And also, if you take the case of Japan, I'm not aware of Studio Ghibli starting infringement proceedings against OpenAI, but just a few days ago, the Japanese government took expressly position regarding the use of Japanese creative content for training purposes. And then, of course, it will be something that will need to be defined through court action and litigation. That is a necessity, but I don't think that right now it should be entirely on the shoulders of right holders to drive the development of AI. Also, governments and potentially also international institutions and organizations should take a position so to ensure that what is a mandate inherent to copyright law, that of striking a fair balance between the rights and the interests of different parties is complied with. So I think it is a collective effort that needs to be done to regulate a technology that is here to stay, but whose potential is yet to be fully worked out. Let's not forget that the movie industry was born out of a technological advancement, so it is an industry based on technology, and it will be indeed inappropriate to think that no new technologies should be implemented, but this for it to be sustainable needs to be done in a way that indeed balances the interest of the various stakeholders that are involved in this type of work.
Okay. And the last question is more like, uh, will there be actually a competition, in your opinion, between legal systems regarding AI and copyright?
That is the idea right now. I think that the answer will depend also on what happens on the side of the AI Act, because if it becomes clear that no matter where you train your model, you need to comply with the EU law, probably this would render also the appetite for having solutions that are very different from European ones weaker objectively. And we shall see also what happens with the many pending US cases. Sure, fair use is a doctrine that is said to be based on the circumstances at hand. But when I hear that, I always wonder what legal provision is not. So it doesn't seem to me that fair use is more than others to be fact dependent. So we shall see what happens there. Again, we have guidance also from the US Supreme Court that probably the first and for fair use factor will not render a blanket AI training on someone's content legal, even in the US. So I think that there will be a convergence at some point between the various legal systems. I conclude by referring to another case that I always hear about, Japan, once again. And many people submit that Japan has a very generous TDM exception, the non-enjoyment purpose exception. I wonder on what grounds these people make such an assertion, because to my knowledge, this exception remains still untested in case law. So, how a Japanese court will construe it, also in the context of AI training, remains to be seen. So, to conclude, I think that going forward, we will likely have greater uniformity around the legal systems rather than divergence, and it is a phase of adjustment like it was the early days of the internet, The real question is not whether we will be similar in the end, because I think that we will, but whose model is going to prevail, whether it is the European one or that adopted in other jurisdictions. That is wait and see. Certainly, the European Union has the first mover advantage. We shall see, however, what happens once the TDM exceptions and the AI Act are construed and applied by courts around Europe, and possibly also with referrals to the Court of Justice.
Thank you. This is a great conclusion. This topic is fascinating, and I have to clearly say thank you very much for sharing your knowledge and expertise. I'm sure that a lot of people have learned a lot today. At least I learned a lot today. So thank you also to the attendees of this webinar. The recording of this presentation will be made available tomorrow. The slides will also be made available on the page of the webinar. And to find out about IP news, resources, interviews, please do not hesitate to follow for IP Council on the different platforms that you can see on your screen. Ideally on LinkedIn, that will be easier. And as we recommended earlier, you can learn a lot on this topic, browsing LinkedIn and maybe following Eleonora Rosati. So you can subscribe also to our newsletter whenever you want. You can also tomorrow, after receiving a short survey, suggest topics that um, you want see them to be covered in the next webinars. So thank you again to all of you for your questions, your patience in organizing this webinar. Eleonora, your paper is great, I have to say that, and I can only recommend anyone willing to learn more to read the paper. Thank you very much and have a good day.
Thanks a lot and have a nice evening.